coffee. Okay. Good morning, everyone. My name is Andy Norton, and I am a realtor with Sampson Properties out of the Tyson's office. And our special guest this morning is Karen Daly, who, let me make sure I have all your credentials right. You are the partner of the law firm that owns Echo Title, and that you manage One Loudoun, which would be the office closest to our immediate audience in Lansdowne Woods, but also Middleburg and Centerville, and what have I forgotten?
Well, so I managed One Loudoun and Middleburg, which is, it's a satellite office. So it's like a nice convenient place because the further out west you go, it makes it easier for folks in that area. And then I'm the assigned attorney for Winchester and Centerville. So I back up there. We have managers in those locations and I back them up. Okay. Along with all the other attorneys at Echo.
And your day-to-day work is real estate closings, correct?
Correct, yes.
Okay. 5 days a week, all day, every day. This is what you do.
Yep.
And you've been doing this for you've been a practicing attorney in Virginia for real estate for over 20 years.
Yes.
Okay. So, in the topic this morning, which is seller-held financing, this is not, as they say, your first rodeo.
That would be correct.
That would be correct, okay. Which is one of the reasons to our audience that I invited Karen this morning, because there are going to be questions that arise. And our audience this morning is primarily Lansdowne Woods, which is going to be a active adult over 55 audience to the video. And on the presumption that something here might be controversial or not understandable readily to our audience, this will be on YouTube and shareable to their adult children, financial advisors, attorneys, and if they really want to get into the weeds, their clergy. Why not? Okay, so I'm going to mention, quote unquote, the lawsuit, because people in Lansdowne Woods know what I'm referring to. But as I have pledged, I will not discuss the parties to the lawsuit, the issues in the lawsuit, or the attorneys for the parties in the lawsuit, because everybody in Lansdowne Woods knows who those people are. But there could be, depending on what happens or not on this lawsuit, reasons why people who are selling in Lansdowne Woods might want to consider seller financing, which is the owner holding the mortgage. And so, having gotten the background out of the way, who you are and what you do, I think I'm also correct that your firm will prepare the mortgage documents if a seller wants to hold a mortgage.
Correct. So that would be a note.
Yes.
And then you would have a deed of trust because you want to have the property securing the note.
And the document that would be recorded in the Loudoun County Courthouse would be?
The deed of trust.
The deed of trust. Okay. And so let's do a hypothetical example, and we'll get into, I'm going to start with 2 + 2 = 4, so bear with me. We'll get to more advanced mathematics in a moment. If a Lansdowne Woods condo is selling for $400,000, and if there's no mortgage at all on the condo,
right,
and if a seller wanted to, for whatever reason, we can get into the reasons later, but if for whatever reason a seller wanted to hold a mortgage, 2 + 2 = 4, if a buyer was going to put down $200,000 in cash, and then the seller wanted to hold a mortgage for $200,000, then as part of the closing process, you and your firm could generate the deed and the deed of trust for $200,000, and at closing, the seller of the condo would get $200,000 in cash less their expenses, right?
About, yes.
About, yes. Okay. As they say, is it too impolitic close enough for government work? Okay.
Yeah, I mean, you have to factor in like the transfer taxes and things like that. So basically, your seller, when they're looking at their bottom line, it's going to be less whatever amount of money they are loaning to the buyer to buy the property. Okay.
So they would be getting $200,000 in cash less those expenses and holding a note for $200,000.
Correct, yes.
Hence my hypothetical, 2 + 2 = 4. And in terms of the terms of that note, that's negotiable.
Yes.
The interest rate's negotiable.
Yes.
And if they wanted to, the amount of it, it doesn't need to be an even round number like 200.
That's correct.
And that's negotiable too.
Yes.
And an advantage. So let's assume in the Lansdowne Woods context, depending on how things shake out, this could be one of the only options of sale that might be available if somebody did not have the full purchase price in cash.
Correct. Yes.
Okay. I'm getting a lot of correct so far.
You're asking leading questions too. So.
This is true. A frequent scenario in Lansdowne Woods would be that somebody is selling to go into assisted living.
Okay.
And either the seller and or their family would need the proceeds of sale in order to pay for assisted living for a certain period of time.
I have seen that, yes.
Okay. And depending on the cost of assisted living, and depending on the length of the mortgage that people negotiate, this could get a seller over a difficult period of time where they get the cash that they need for a certain period of time. And in holding a mortgage, it doesn't have to be for 30 years. Typically, it would be for much less than that.
Right. So typically what I see, although it's not, I have seen a 30-year seller financing situation,
Okay.
But typically what I see is it's usually you're talking a short time period, like no more than 5 years. The common types of notes that I will see are balloon notes. So they're paying maybe an interest payment, and then at the end there's a lump sum that's due. That being said, you can structure it so that they are making a certain amount that's applied towards principal and interest throughout that time, and then calculate, okay, at the end of 5 years, it's still a balloon, so there's still a lump sum that you have to pay off.
And we'll get to a balloon in a second, because some people in the audience may not be familiar with a balloon, and but the interest rate payments typically don't have to. The buyer would be paying the seller every month a mortgage payment, as they would be to a mortgage company, typically on the first of the month, and that would be a regular cash flow that the seller would receive during the term of the note.
Yes.
Okay. And so let's talk about a balloon. So at the end, let's say, for example, this is a 3-year note or a 5-year note. At the end of that term, whatever it happens to be, it's negotiable between buyer and seller. The balloon means that the buyer would owe the seller the entire amount of the funds that are left to be repaid.
Yes.
Okay. And so even though I started with an example of a $400,000 property and a $200,000 mortgage and $200,000 in cash, this is equally applicable, yes, to a $500,000 property or $300,000. Okay. Yeah.
Yes.
Other common Lansdowne Woods scenarios, folks, and it doesn't have to be 50-50. So it could be, in the $400,000 example, a $100,000 down payment or a $300,000 down payment. Basically, this scenario is to enable sellers of condos in Lansdowne Woods, if they need this, to sell and get on with their lives, whatever it happens to be, and as opposed to, let's say, either not selling at all or renting.
Right. And the pros also, some of the pros of having what we call seller financing is that you don't have to worry about a credit report for the buyer, right? The typical bureaucratic red tape that you see with a traditional lender, that is not present. So there are some advantages for the buyer with saying, okay, I would like to, do and talk to the seller about seller financing. But some of the cons are, you want to wait to get to that? I saw you put your finger up, so okay. It's not a lot, but there's a couple that come to mind. So
and so I've been speaking about the pros, and I was going to get to the cons.
Okay, sorry. I jumped ahead.
So an obvious answer, a question that people in the audience might have is, what happens if the buyer does not pay either the mortgage payments when due or the balloon at the end? These are cons that I think you were about to mention.
One, yes, but there's also, so before I get to that part, the other con is the application of the payments throughout the period. So a seller who is holding the note and receiving the payments, they're not as sophisticated, say, as a lender who has systems set up to say, okay, this is the money that comes in, this goes to principal, and this goes to interest. So one of the things that you want to do and want to ask about if you are going through this scenario is to have what's called an amortization schedule.
Yes.
Those are really easily generated on the internet. And so to have that and to give that to the buyer, and then the seller, perhaps maybe talk with your financial advisor or accountant, but to figure out a way that you can track how those payments are applied. Yeah. So that's one of the, before you even get to the default part, sorry, I say default, that's a big word, or I'll come back to that in a minute. Yeah. But before you get to that part where the borrower is not performing, you want to make sure you've got a good system to apply those payments across the board.
Okay.
Now, to your question, what happens if the borrower, does not perform? What if they don't make their mortgage payments, or at the end, if they don't make what is due? So in the note and the deed of trust, this is another plug why you want to have an attorney draft this up. Don't get it off the internet. There are going to be terms that are provided for what happens in that scenario. Now in Virginia, this is what's really interesting. So this is why you want to have a deed of trust also. The deed of trust, the lender, in this case your seller, they are the lender, so they can foreclose on the property, and you would follow that process that's laid out in your deed of trust. And then separately, if they don't get this full amount that's due under the deed of trust, they can still come after the buyer for what's called the deficiency. So that would be the balance between what they received at the sale versus what is owed. So that would be the difference. But that is a separate court action that the seller would have to file against the buyer.
Okay.
Buyer-borrower.
2 points with respect to what happens if this goes south. Okay. One is an editorial comment from me, just bear with me on this.
Sure.
That in Lansdowne Woods generally, and I think in the senior population that I have worked with in Lansdowne Woods for 15 years now, usually at a certain point in life, the buyers in Lansdowne Woods are financially responsible. Okay.
Yes.
Yeah. And so we're talking about something that can happen, but I'll just say Andy's editorial is highly unlikely that it would happen. And kind of backing that up, I'm trying to think, in 15 years there, if I have actually seen, I think I've only seen one foreclosure in 15 years. I mean, it's not common that a seller would have to do this.
So you're basically, what you're saying with this, I think, is that your risk is low as a seller. If this is something you want to do, and you always have to key this in what's high risk versus low risk.
Correct.
Because there's always a risk.
Yes.
I can think of a few scenarios where a buyer-borrower might default, and that would be if their health goes down and they have to be hospitalized. Okay. So there may be a focus, with that. You're hoping, though, that the relationship, though, between the seller and the borrower, or in this case, it would be the lender and the borrower, is good, that they can have that communication to say, hey, here's what's going on, and to try to work out some type of payment, which is why, too, having your kids be aware of this is helpful.
Yes. So speaking of the kids, the adult children to our audience.
Yes.
Because another common scenario, all too common I'm afraid, is that in addition to a seller needing the proceeds of the sale of the condo to go into assisted living, if they pass while they are in residence at Lansdowne Woods, then we're dealing with adult children who are looking for the money as part of their inheritance. Yes,
and this is where you want to have good estate planning. Because even though
Yes.
the seller dies and they're the lender, the estate is the one who then becomes the lender.
Correct.
So the money would go to the estate, and it may be, depending on how they've got it set up, it may be the kids. There's some more unraveling to do, which is probably more than what would be appropriate for this video. But it would. I have seen scenarios. So this is too why you want to make sure when you've got your note and your deed of trust drafted that it's done by an attorney, because I have seen scenarios where the seller individually has been the lender and they have died. And then the kids step in to start trying to manage it, and if it's not clear, it can get messy when you try to go to sell, or you're trying to figure out, okay, what are our options and who can do what.
Which would be, I think, one reason why the realtor who handles this, number one, and why you, when it comes to your desk, number two, would be encouraging clarity with respect to the estate.
Correct. Yes. Yes.
Okay.
Yes.
And in the case where somebody has passed, bear with me on this, it would be the heirs who would have to divide the proceeds of the sale, less their expenses that they get on the sale, and then have an agreement as to the money coming in each month, how that is divided, what the accounting is, and then when, at the end of the loan term, when it quote-unquote balloons and that cash comes in, how that money will then be split amongst however many heirs there are. Did I say that right?
That's a lot. That's quite a. It's fairly simple explanation, I think, of what could happen. You want to make sure that you've got good estate planning, regardless.
Yeah.
The property drops like a rock, but the note is an asset of the estate.
Okay. You used an expression from continuing ed classes that they may not know.
Sure.
What do you mean by the property drops like a rock?
I mean, it immediately passes to the person who inherits the property. So you, for maybe a little bit analogy here, you don't have to pass go. You don't have to collect $200. If you like Monopoly, you'll recognize that reference.
Okay.
It immediately comes.
Okay.
I love Monopoly, what can I say? But back to my point, the property immediately comes to the person who inherits it. So there's nothing that, and I get this question a lot, there's nothing that you have to do to show that you're the owner.
Okay.
Because it immediately happens. What you're doing by filing documents with the courthouse, whether that's the will or a list of heirs documents, so those are some documents, you are telling the world, here's the chain of title and why I have the power and authority to take certain acts with regard to this property.
Okay. In a situation where somebody dies and you're dealing with an heir or heirs, they could, as a different option, simply rent the property. Yeah.
Yes, they could.
Okay. But if they're looking for a sale, and if due to factors that we cannot foresee with respect to this lawsuit, if they want to sell, this could be a viable option for an heir or heirs in that scenario.
To sell the property.
To get it sold as opposed to not.
Right.
Okay.
And I want to be clear, because for a while we were talking about when the seller/lender has died, and the heirs want to sell the property. Correct. If the buyer is still in the property and they're making their payments, they'd all have to, agree to sell the property or to reconcile that last part. The heirs couldn't just say, okay, well, our parent died, we're going to sell it, even though there's someone in the property making their mortgage payments.
Because if the buyer with this owner financing scenario is in the property making timely payments, the mere fact that the note holder, in this case the seller, has passed away doesn't mean that the adult child or children can boot that buyer out. It's still the buyer's property.
Yes, that's correct. Yes.
And the buyer's deed, by the way, the deed gets recorded at the courthouse. So that
it does.
The person buying this does indeed still own it.
Right. So I always tell people, when you buy property, even in seller financing, right, you are getting what I call a bundle of sticks. So just think of all of your interests in the property as sticks, right? Grab a bundle of sticks, bundle of pens, if that helps it make it easier. And then you're giving one to the seller because they're the note holder. And then Virginia is what we call a non-judicial foreclosure state, meaning you don't have to go to court to get the foreclosure to happen. And then so the other stick goes to the trustee.
Okay.
And they hold what we call bare legal title.
Is it a fair statement logically, if not legally, that if in the case of this $400,000 property and a $200,000 down payment and a $200,000 note, that most buyers are not going to lightly walk away from $200,000 of equity?
I think that's a fair statement. And probably more equity because obviously the longer you're in the property, the more your value goes up because you're paying down the debt, but then you've got other market factors too.
Okay. So while we've been talking about what could go wrong,
yes,
it's not a highly likely scenario that it will go wrong.
Yes.
Now, other examples that we could do, it doesn't have to be 50%. Whether it's a 300 condo, a 400K condo, or a 489.5 condo, the amount of the sale price and the amount of the mortgage that the seller takes back is entirely negotiable between the buyer and the seller.
100%. 100%.
Okay. The interest rate, so have you seen any of these lately, a seller-held note, in the past couple of months, maybe?
Not in the past couple of months. I'd say within maybe the last 6 months.
Okay.
And I've seen them with no interest rate, although at the end there's an interest rate at the end that's applied. I have seen the IRS actually has a daily interest rate that can be used. So you, like, I Google it and see what it is for that particular day. Or the parties can say, hey, this is the interest rate that we're going to put on the note. So the benefit of doing seller financing, in addition to no credit report, you know, the bureaucratic red stuff, is the interest rate. Because right now your interest rates are 6.79 or higher, right? So if you're doing seller financing, you can actually have it lower.
Yeah.
Which is more favorable for a buyer.
Yes. So we've been speaking of the advantages to a seller doing this.
Right.
There are plenty of buyers who come to Lansdowne Woods and they want to make it their forever home. And they don't have the cash for a 100% cash down payment. There is an advantage to a borrower here, even if the rate is not lower than market, to simply pay market. Yes, and if a buyer were going to be looking at, let's say, 6 3/4 on a 30-year fixed rate note with the bank, and they were to pay a seller 6 3/4, that would not be, quote unquote, unfair to a buyer at all. Okay. And the seller, for their part, would be getting a much higher rate of interest than they would get at a CD at a bank.
Exactly. And the other, but again, back to an earlier point, is the seller needs to have a good system when they get the payment from the buyer, is to apply the appropriate amount to the interest and then to the principal. So you've got to make sure if you're going to go down that path, you've got that set up.
Are there things that I, as a realtor, or other realtors should be doing when we have conversations with sellers about this to assist them in having those pieces in place to apply the interest and the principal on those mortgage payments correctly?
I would recommend that you, as a realtor, say, direct them either to talking with their financial advisor or a tax accountant, because this is not in your lane. And sometimes that's hard because realtors, attorneys, we all like to be the fount of information. But sometimes...
You're saying I'm not the fount?
You are. You're very...
Okay.
But sometimes...
Folks, I'm the exception to the rule. You can just call me the fount. Okay.
But sometimes there are instances, because it is such a specialized area,
Yes.
That it's better to refer them to their financial advisor or tax accountant to work through that. One, it keeps you safe liability-wise, and it helps also to make sure they have their expectations met and you're not coming in and setting unrealistic expectations. So you don't want to overpromise and underdeliver.
And as the attorney who's both drafting the note and with Echo Title closing the sale, I take it you're totally comfortable speaking with the seller's financial advisors, whoever they happen to be.
Yes, and I have done that in the past where the seller's financial advisors have reached out and they've said this is what it is, and they've helped structure the terms of the note. And of course, the buyer has been kept in the loop, so they're aware of it, and everybody's on the same page about it.
Okay. One of the things that we were discussing off camera before this started is that by coincidence, you're going to be teaching a class tomorrow to attorneys on this very subject.
Yes.
Okay. As an attorney yourself who specializes somewhat in the subject, you're teaching a class to your peers.
Yes. So that's routinely done. As attorneys, we have to keep up our legal education.
Okay.
So other attorneys who have experience in that particular area will come and instruct those of us who don't, and we'll learn something and also keep our licenses.
Which brings up an interesting point, that if a seller, and many in Lansdowne Woods have attorneys who have helped them with wills and estates and trust work.
Right.
Typically, somebody who concentrates in wills and estates and trusts would not necessarily have the expertise to be drafting a note and a deed of trust. Is that fair?
Well,
I mean,
so
isn't this the audience that you're going to be speaking to tomorrow, theoretically?
No, this is how the bar and the American Bar Association approaches attorney licensure, right?
No.
If it's something we can study and teach ourselves on, then we can undertake it. But we have to basically the saying is take yourself to school. So go to the library, do research, take classes, study it if that's going to be something that you're going to do. A lot of times the attorneys may look at it and say, hey, look, just knowing my caseload, what I've got going on, this is better if I send it to someone who this is the area that they focus in, that they do. And so it's become that way because the law obviously has developed so much and there's so much out there. So that is quite common.
Okay. Knowing as the precondition of this video that we're speaking to an audience of seniors and potentially their adult children, financial advisors, because this will be on YouTube. And is there anything that comes to mind offhand that we haven't discussed that you would think, let's say if it were your parents and they were, let's say, active adults. I don't want to presume what age your parents might be. If they were your parents, that you might say, Mom, Dad, you should be looking at this issue or that issue that we may not have discussed yet this morning.
I think probably the last thing to tie this all up is to have numbers, like what you guys call a net sheet. I find that helps sellers understand, because in theory, it sounds great. Okay. And then once you see how it breaks down on paper, you realize maybe this won't work, or I've had some conversations where there hasn't been enough equity in the property to even go down this route as an option. So
let's talk about not having enough equity in the property, because part of this, we've been talking about properties that are free and clear with no mortgage.
Right.
If, for example, somebody had a mortgage, they could use the cash, depending on how much the mortgage is and depending on how much cash the buyer is bringing to the table, to pay off the existing mortgage, yes?
What you're going to want to look at is the sales price. Is that enough to not only pay off your mortgage, all of your closing costs as a seller, but also to deduct the note that you're going to be lending, or the money, I should say, the money that you're going to be lending to the buyer. Because that will play a factor into what your sales price is going to be. That's going to be your driving factor.
I think I know the answer to this. Am I correct? There really isn't a little brochure like everything you wanted to know about seller financing but were afraid to ask?
There's not.
There's not.
And the reason, in part, I think, is what this discussion has really shown.
Yes.
It's so specialized as far as each individual party, right? So it's not a check the box, here you go, we're going to put it into this nice, neat box. There are negotiable terms that you don't necessarily have with a traditional mortgage. So it's very flexible, and there's not a one-size-fits-all. You have broad guiding principles, but there's not really, that I'm aware of. Maybe they're changed, I don't know, but I'm not aware of any brochure out there.
To the audience, if I find such a brochure, I will definitely let you know. There will be a follow-up to the video announcing the brochure. Although maybe in what passes for free time in Karen Daly's world, you could write such a thing.
Oh, sure.
Yeah. You should also tell the audience how they can reach you and how their family members and advisors can reach you, because as a realtor, can I assist you in the sale? Yeah, but the person who is actually going to be the attorney and the note would be, how can they contact you?
So my information is on our website, www.ekkotitle.com. You can also find me on Facebook, Instagram. Our phone number, my office phone number is 703-573-3556. And then my email is K and Daily, like Daily Planet or Daily Bread, whichever superhero you like.
Sorry.
It's okay.
We're getting punchy on the video
here.
Your email is?
kdaily@ekkotitle.com.
Thank you very much for being the guest this morning, and I trust that the audience of Lansdowne Woods specifically, but really what we're talking about applies not just to seniors in Loudoun, but more broadly throughout the Commonwealth of Virginia.
Yes,
yeah,
absolutely.
Okay, thank you everyone, and I will be getting the link out within Lansdowne Woods, and you'll be able to watch this probably, depending on the schedule of our esteemed videographer, as soon as tomorrow, which would be Wednesday. Thank you everyone.